Good morning, everyone. Thank you guys all so much for being here today on this early Saturday morning and sticking with us throughout the whole conference. I'm really excited to be a part of this panel here today. We have just a really wonderful set of panelists ready to speak to you this morning on the impacts on victims and witnesses of crime and punishment. My name is Molly Spalding. I'm a clinical fellow here at the University of Texas Capital Punishment Clinic, and I want to introduce you to our wonderful panelists here today. So this morning I have 5 speakers who will be talking to you. First we have the Honorable Rennie Cushing. Representative Cushing is the founder of the Murder Victims Families for Human Rights, and he's also a member of the New Hampshire House of Representatives. He's been involved in various efforts to create a Victims' Bill of Rights, a Victims' Advocate Programs, and a Victims' Compensation Fund. And Representative Cushing has traveled the U.S. and the world speaking out on behalf of victims who oppose capital punishment. I also have Kristen Houlé here with us this morning. Ms. Houlé is the Executive Director of the Texas Coalition to Abolish the Death Penalty, where she has served since 2008. The Texas Coalition to Abolish the Death Penalty is a grassroots organization located right here in Austin. Previously, Ms. Houlé was a Soros Justice Fellow, where she conducted research and public education around the intersection of the death penalty and severe mental illness, and she also served as a program associate for Amnesty International's program to abolish the death penalty. Third, I have Mr. Walter Long here with us. Mr. Long is a UT graduate, and in fact, he is an alum of our Capital Punishment Clinic here at the University of Texas. He's been practicing death penalty habeas law in Texas for 2 decades now. Mr. Long he has a master's degree in counseling psychology, and he has a profound interest in the public health consequences of litigation and the restorative justice movement. In 2007, Mr. Long founded the Texas After Violence Project, which collects and archives oral histories of persons affected by private and public violence in Texas. I also have, over here to my right, Ms. Michelle Lyons. Ms. Lyons served as the spokeswoman for the Texas Department of Criminal Justice for over a decade. In this role, she managed media access to Texas's death row population, and she coordinated media witnesses who would view executions. Prior to joining TDCJ, Ms. Lyons was a reporter for the Huntsville item, which in that capacity and in her capacity at TDCJ, she witnessed over 280 executions. And finally, I'm very excited to have Mr. Anthony Graves here with us today. Mr. Graves is known as U.S. Death Row Exoneree 138. He spent 18.5 years behind bars. 16 of these years were in solitary confinement, and 12 were on death row. Mr. Graves had 2 set execution dates during his time incarcerated for a horrific crime that he did not commit, which was the 1992 brutal murders of 6 people, 4 of them children, in Somerville, Texas. And after an incredible turn of events, Mr. Graves' charges were dropped and he was set free. And prosecutors reviewing the case found that not only was Mr. Graves innocent of those crimes, but that actually the prosecuting attorney on the case had engaged in numerous acts of prosecutorial misconduct. Mr. Graves now travels the United States and the entire world, enlightening politicians, criminal justice reform organizations, law students, and the public about the need for comprehensive criminal justice reform and the injustices found in our system. So we're going to start with Mr. Rennie Cushing this morning, but I would like all of you to give a large round of applause for our great panelists.
Good morning. I'm Rennie, and I have 2 hats that I guess I'm wearing. One is a state lawmaker. I happen to dawn on me as I've been sitting here for the past couple days that I'm probably the only person here that's ever voted on the death penalty. And I've done it a number of times, and I just, 2 weeks ago went through somewhat an excruciating process of, 1, having to defeat a death penalty expansion bill, and 2, watching a death penalty repeal bill falls short because tie goes to the executioner in my state, or in every state. So I have that view of being a lawmaker that I bring to this conversation. In New Hampshire, there's a saying that you can always tell a legislator, but you can't tell them much. And that may be true. That may be a shared experience that you have when you meet other lawmakers. And the other thing I bring to this is that I'm a survivor of homicide victims. You know, a quarter of a century ago, my father was shotgunned to death in front of my mother in our family home. And I guess from that moment, thinking what you do in the aftermath of homicide stopped being just an intellectual exercise for me, but instead it became a part of my life and the life of my family. And then have I, you know, in what might be even more incredible to me in some ways is that 5 years ago, last Monday, my brother-in-law Stephen was, took 7 bullets from an FN-7 assault pistol and was murdered on his front step. So those two experiences, I think, shape me, and I'm here to talk to you about it. And they also, interestingly enough, shape who I am as a legislator. I think that there's a real, what I struck is the difference between litigation and legislation, the difference between a state house and a courthouse. And it's been somewhat refreshing to sit here in kind of in a thoughtful, intellectual atmosphere and discuss in a pretty rational way what the death penalty is about. But when you get outside of the confines of the courthouse and the academy, it's a lot different. Because obviously the reason we have a conversation in the United States, at least now, at this point in our history, in 2016, is because, quite frankly, people are murdered. We don't give the death penalty for apostasy or, other crimes anymore, sodomy, the whole list of what used to be. But it's because people are murdered. And when you strip away everything like that, what we need to do is, in some ways, what we're trying to do is figure out how we deal with the aftermath of murder. One of the things that I find interesting in recognizing and looking at the recent history in the past 40 years is seeing that both the Furman and Gregg were kind of a culmination of this litigation-led strategy to repeal the death penalty that was a conscious part of the civil rights movement. Well, that civil rights movement also gave birth to the victims' rights movement, if you will, that grew directly out of the experience primarily of communities of color and also gender experience, where crimes against certain people weren't recognized as crimes. If you look at, for the women's movement, that was true, that if you weren't a virgin, and it was okay to rape you. If it's okay to beat the shit out of your wife because she was your property. And I think growing up from a criminal justice system that was insensitive to the needs of victims gave right to the victims movement. And although there's no formal place for victims in this courtroom setting like this, in a criminal setting, nonetheless they're stakeholders. And what took place in the aftermath of the Gregg decision was also the development of a modern abolition movement, but there also was a parallel development of a victims movement. And although they shared common roots in some respects for a generation, I think they lost the ability to see that and moved in parallel directions forward. It's interesting that 1976 marked the beginning of the birth of two other organizations. This is the 40th anniversary. One is Parents of Murdered Children, and the other is the National Organization of Victims' Assistance. What people might not know is that the founders of Parents of Murdered Children, the Hulligans from Cincinnati, Ohio, who wanted to assert that, they were opposed to the death penalty. And what you might not know is that the people who started the National Organization for Victims' Assistance were really clear about the failures of our criminal justice system, and that's why they were in place. And the question I would ask, there was an allusion, it was alluded to yesterday, of how in the aftermath of Gregg, the tables will run in the state legislatures. That, yeah, there were 38, in the next 20 years, there were 38 states that reinstated the death penalty. And the question I have is, why did that take place? And I would submit that because the abolition of the death penalty was really litigation focused, and it was focused upon what the death penalty does to the person upon whom it's imposed, and that was the appeal that was made in the courts that was successful. But why was it not able to be sustained in the court of public opinion, in the state houses? And the reason it was is because there was not the capacity of the legal community at that time to understand the political ramifications of it and to work in an arena other than the courts. And in a way, there was a paradigm that was accepted by both proponents and opponents of the death penalty that was this, that all family members of murder victims wanted the death penalty for the person who killed them. And that because of that, our political leaders were under almost a moral obligation to provide an execution solution to victims' pain. And those political leaders who didn't do that were insensitive to the needs of victims. And there was a conflation. It became like to be anti-death penalty is to be anti-victim. And the interesting thing about it is that was accepted by both the proponents of the death penalty, but I also think it was accepted by the opponents of the death penalty, because I fail to see in any of the literature that I've read where there was a consciousness or understanding of what the experience of victims was. And what you saw in the State House battles for 20 years is that the face of the forces that wanted the reinstatement of the death penalty were always the victims. It was done in the name of victims, and I think that was seeded and accepted by the defense bar as well as the bar, because you didn't want to have to talk to them. But I think things changed. We'll look. There was a history that was recited that included Mike Dukakis in 1988's inability to respond when his wife was, the question of what would happen if your wife was raped and murdered. We fast forwarded 4 years later to see Bill Clinton stand up and, kill Ricky Ray Rector, but he was actually really killing Willie Horton, who was the symbol of the person that Mike Dukakis couldn't figure out what to deal with because he was a killer who went loose. And for a long time, Mario Cuomo was the hero. And when he was taken out in 1994 in that election, it was assumed that that it was all over, that there wasn't going to be any way that we would be able to stop that, because when Mario Cuomo when Pataki signed his first bill into law, that reinstating the death penalty in New York, standing next to him on the podium was the brother of a slain state trooper. But what people didn't know was that the daughter of that slain state trooper, was opposed to capital punishment, was one of those quiet family members of murder victims who weren't looked to, who weren't listened to, who weren't recognized. Her name's Kathy Dillon. But, and as we saw, we went from the low point of the death penalty, or the high point, depending on your view, I think we'll all agree took place in Massachusetts in 1997, when the 39th state legislature voted to reinstate capital punishment, and did so because of a homicide of a 9-year-old child that happened in Cambridge, and his father drove Massachusetts legislature to reinstate the death penalty, to do something about for family members of murder victims. Ultimately, that turned around because some lawmaker changed his perspective. But there was accepted that this was all about the name of families. You wanted to do that. But an important thing happened, I think, in the terms of the politics of the death penalty, and that was the same year where there was an open election for Congress in Illinois, and Jan Schakowsky was running against another candidate for a primary, and the campaign rested upon this. There was an ad that was on the TV. It was a picture of the Oklahoma City bombing, and the commercial said, Jan Schakowsky's so wimpy, she opposes the death penalty even for people like Timothy McVeigh, like the Oklahoma City bombing. Defense attorneys couldn't respond to that. No one could really respond to that, except there was a guy from Oklahoma City named Bud Welch who came to Illinois, who stood up and said to Schakowsky's opponent, "My daughter Julie was killed in the Oklahoma City bombing. How dare you make a political football out of my daughter's murder? I demand that you take down those advertisements." And the guy ended up backing down, and Jan Schakowsky won. And Jan Schakowsky points to that as the reason that she became members of Congress. So what we saw for the first time in a way to stem the tide in public opinion was to see a family member of a murder victim stand up and say, not in my name, you're not going to, you're not going to garner stuff from, from that. And I think that and the Curley murder, that represented kind of a sea change, because what happened is, as we saw parallel, there was a development within the abolition movement of a small group of people who had an identity of both being abolitionists but also survivors of homicide victims, and who were challenging both the paradigm both within the abolition movement, but also work was being done within the victims movement itself, because the victims movement had taken upon itself to say it was speaking on behalf of family members of murder victims. And in a way, for a long while, you would see victims advocates organizing family members of murder victims to come to appear at legislative hearings to say, well, we needed the death penalty, we wanted to expand the death penalty because it was for victims. And think about what this is. You have victims advocates going to, corral in family members of murder victims to advance a public policy. And the question, though, that was asked is, if the promise of victims movement is empowerment, if it's about dignity, if it's about, do you accept that there's a multiplicity of views or diversity of views upon the death penalty within the victim population? And I think some of us began challenging that notion that within the victims community, that you should always equate support for the death penalty with what a victim wants, and challenging, why are you providing the services to victims who oppose the death penalty and granting parity of esteem with those who support the death penalty? And that's been part of the work that's gone on, I think, in the past generation through a number of different organizations. The National Organization of Victims Assistance put out as part of their concern for meeting the needs of victims, developed this training video called Finding Resolution. What Finding Resolution was about is how do you help, since the modern death penalty has taken to incorporate victims into the pageantry of executions by having their reserved space as a, at the execution itself, and getting some finger food out for the family that they can have before and afterwards, and trying to meet the needs of that. How do you serve the needs of that? In the Finding Resolution video, when I first saw that, what struck me about it is that I wasn't in that video, that they unveiled it at a National Organization of Victims Assistance conference in 2000. Because what Finding Resolution was about, it was trying to help victims deal with the question of whether or not they should attend the execution or whether they shouldn't attend the execution. It was almost as though those are the only two choices, those are the only two questions that victims really have when this ritual killing takes place. And the reason I challenged it is because absent from that video were the family members of murder victims who were opposed to the death penalty. And that video no longer is part of the protocol, because what that did is that invigorated a discussion process within the victims movement, which quite frankly could not have been done by defense attorneys. It could not have been done anybody else except by victims themselves, who had the moral authority and the authenticity to challenge the paradigm and the culture that had been created in the victims movement itself. And you saw within that victims movement a point where there is almost uniformly recognized that victims have a role here in things to play. Interestingly enough, Mary Achilles some of you may know, Mary Achilles is the person who developed what's known as the Achilles Protocol, which is used in many jurisdictions to help victims assistance people get victims through executions. Mary went on to work for the NCADP as somebody who did victims outreach, trying to, again, build those bridges. I got the 1-minute warning. I'd like to talk more about legislation and victims, but I'm going to be respectful of this time and this process. But I do want to say that I think that what we're trying to, I do think that there are times that still where I find the most difficult thing I have to overcome with other victims to talk about the death penalty is the anti-death penalty movement. I say that respectfully. But I had a situation a couple of years ago where I had sponsored legislation to fund cold case homicide in my unit. And I get done, as I testifying I had someone testifying, a friend of mine, Carol Stamaticus, who's opposed to the death penalty, who's, testifies on behalf of against the death penalty in the legislature, but also her father's murder is unsolved, and she talked about what it means to have resources, poured into trying to execute a few number of people while, a majority of the homicides go unsolved, and what it signals to the value of families about their loved ones. And what struck me is as soon as Carol got done, the next person up was this guy, Chris Dornan, who was the leader and the founder of Citizens for Criminal Justice Reform, who testified against the bill. And I think he testified against the bill because on some level, they equated, like, if we solve cold case homicides, those are going to be more death penalty cases. Rather, we just let people get away with murder than try to put resources into solving that, as though it's going to end up being a zero-sum for victims, that if you solve homicides, that somehow you're going to make it worse for offenders. And I don't think we can do that, because I think more important than whether, who wins some of these legal cases is that we find justice and then we find healing. And solving unsolved homicides is a really important thing to do. I don't want to kill people who kill, but I don't want to embrace impunity. Because when people get away with murder, it just devalues everybody. Thank you.
Good morning. Thank you so much for inviting me to be here today and to participate on this amazing panel. Again, my name is Kristen Houlet. I'm the Executive Director of the Texas Coalition to Abolish the Death Penalty. TCADP is a statewide grassroots advocacy organization that works to raise awareness of the flaws and failures of the death penalty in order to shift public opinion and reduce use of the death penalty, particularly here in Texas. Our activities include such things as strategic communications, constituent advocacy at the county and state levels, public education, outreach to key constituencies such as faith communities and civic groups, amplification of unusual voices, and support of litigation strategies. I wanted to focus my remarks on 3 areas this morning. First is just to give you a sense of the impact that victims and witnesses have on advocacy efforts and how they are really changing the conversation on the death penalty around this country. I want to give you some examples of how we work with victims and witnesses as an advocacy organization and some of the lessons that I've learned in the course of doing this work over the last 17 years. So it may go without saying, but I think it's really important just to talk about the tremendous and significant impact that victims and witnesses have on advocacy efforts and changing the conversation. You really cannot overstate the way that a storyteller like Anthony Graves, like Michelle Lyons, like Rennie Cushing can take a member of the public who has never thought about the death penalty before, or who may think that he or she supports the death penalty, to opposing it. Sometimes often within 45 minutes, you can take someone who believes themselves to be a hardcore supporter of the death penalty to someone who opposes it. Or you can really strengthen someone who may have felt ambivalent about the death penalty or wasn't sure where they stood to someone who opposes it. So I wanted to just share with you some representative comments that we have received from people who have been in the audience and hear these stories. We work a lot with Witness to Innocence, a national organization composed of death row exonerees. They have a really terrific evaluation form that we can provide to audience members, and it asks them first to indicate what was your position on the death penalty coming in to the event, and then what was your position leaving it, and then some comments. So, again, the vast majority of people say either they didn't know what they thought about the death penalty and then left the event opposing it, or came into it supporting the death penalty and opposing it. I don't think I've ever seen an evaluation survey where someone came in opposing the death penalty, heard Anthony speak, and then left supporting that. It just doesn't happen. So just to give you a sense of, again, how powerful these presentations are, these are some representative comments from an event that we organized a couple years ago featuring Mr. Anthony Graves and Jan Brown. Jan's 9.5-year-old daughter, Candy Kirtland, was kidnapped and murdered in Bryan, Texas, which is Brazos County. This event was taking place at Texas A&M in College Station, where the murder had happened. So folks wrote on their comment forums, "It changed the way I looked at the death penalty. Now that I've heard their stories, I don't think the death penalty is necessary." Another person wrote, "I learned a lot of new things and I have stronger opinions against the death penalty now." Another quote, "This was the first time I heard a victim say she opposes the death penalty." Another person wrote, "It popped my sheltered bubble. If there are cracks in the system, it's not worth keeping." We also have done some work a lot of work actually, with death row exoneree Juan Melendez, who spent nearly 18 years on Florida's death row. And we partnered with him and former District Attorney Tim Cole, who I hope many of you had a chance to hear on Thursday, to do some speaking events in the Dallas-Fort Worth area. And again, people were just absolutely floored by their presentations. One person wrote, "I was never sure where I stood about the death penalty. Hearing Juan's story and being able to put a face to the cause truly changed me." Another person wrote, "Juan's story was very insightful and impactful. I never had reason to think much about the death penalty, so it was great getting that insight." We also heard numerous other people who said, "It motivated me to take action and be more conscious of this injustice. If every person who thinks they believe in the death penalty could hear these stories and meet Juan and Tim, their hearts would change." We also see the impact that victims and witnesses have on members of the legislature. It can totally change the conversation at a legislative committee hearing. We find people who still support, legislators who still support the death penalty, want to have their picture taken with Anthony after he testifies in front of them. I'll never forget another hearing we had where the Texas legislature was trying to expand the death penalty. They wanted to lower the age for victims to make it an eligible capital crime from the age of 10 to the age of 6. So we had Jan Brown, again, whose 9.5-year-old daughter was kidnapped and murdered, testify in front of them. And the committee chairman did a double take when she said that her registered position against the bill was opposed to it. He actually questioned her, I think 2 or 3 times, said, "Are you sure? Are you sure that you filled out the form correctly? Are you sure that you're testifying against this bill?" Because again, as Rennie mentioned, I think particularly state legislators in Texas do consider victims and survivors a monolith, and it was very, very impactful to have Jan testifying in front of them. These folks have immense credibility. They are unassailable voices, and we could not be doing this work without our partnership with them. So some of the examples, in addition to speaking events and legislative testimony that we do, and I want to mention that this is work that is happening all over the country. It's not just what we do in Texas. We have Stacey Pratt from Missouri Coalition doing this work. I mean, if you are outside of Texas and you are not in contact with your state coalition, I really urge you to be in touch, because they can be very helpful in your work. We work in many different ways with victims and witnesses as an advocacy organization. In support of litigation strategies, we will reach out to and engage victims and witnesses, including murder victims' family members, exonerees, former members of law enforcement, and families and friends of death row inmates, in sign-on letters that may be presented to a district attorney, urging them to support a new sentencing hearing in a case. For example, we'll work with them on submitting letters to the editor to paper in response to coverage of specific cases, or to try to convey a particular message about that case. Also work with them on op-eds. We work to connect victims with litigators to develop amicus briefs for cases. We also do legislative testimony. We work with connecting victims and witnesses with journalists, with documentary filmmakers, and again, a lot of public education activities, speaking events, panels, and workshops. So just a few things that I wanted to share about things I've learned, best practices in doing this work. This work is all about relationships. It's about building trust, building credibility. It does not happen overnight. It takes a lot of time. We can't just manufacture a list of victims' family members to support a particular effort. We really have to take the time to develop the relationships, and that means also, checking in with victims' family members just to see how they're doing, not just because we need something. It means being sensitive to key moments in their lives, being particularly sensitive around holidays or around the anniversary of their loved one's death or around aspects of their trial or their exoneration. It means being aware of certain triggers, particularly in working with exonerees on speaking tours. I become very aware of, the ongoing impacts of their confinement, whether that means what time they like to eat breakfast, whether they don't like to eat breakfast because it was served to them at 3 o'clock in the morning and was covered with cockroaches, the temperature of the food they like, what they need at the end of the day, what they need in order to continue to do the work, because what we're asking them to do is to share the worst moments and the worst stories of their lives with audiences, and we ask them to do it over and over and over again, and the least we can do is to be sensitive and aware of what they need and some of the things that may trigger them. I'll never, one of the most horrible things I ever did, I think, to an exoneree was to put him in a room with no windows and no ventilation and ask him to record a podcast, and I felt like that was, I couldn't believe that I did that. It felt like such an insensitive thing to do. I'm so surprised he still speaks to me. Also, particularly when working with victims, you need to know the crime details, right? And I remember calling up one of the victims' family members that I work with extensively, and I said, I laid out all the reasons why this case was such an injustice and what we needed her to do and how she could be helped. And she said, Kristen, I'm happy to help, but what did he do? What was he convicted of doing? And I was like, yes, of course I should have started with that. It was so important. Let's see. I guess the last thing is compensating people fairly for their time. I think it's inappropriate to expect people to take time out of their days to share their stories, to travel to states and do 2 or 3 speaking events a day, and to not compensate them for their time and treat them fairly. The last thing I just wanted to say was, I think it's very important as advocates not to speak for victims and witnesses. We can share the stories of people we know, the people that we work with closely, but we are not here to speak for them. We are here to facilitate opportunities, to empower them to share their stories. But I think we sometimes in the advocacy community fall guilty of doing just what Rennie had mentioned earlier, of treating all victims as a monolith, as if now that we have victims that we work with, as if all of them oppose the death penalty and all of them believe that the death penalty is harmful to victims. That's simply not true. There are victims, there is a diversity of perspectives. Our work is to amplify stories and to provide opportunities, but we are not here to speak for victims as advocates. So that's just a very short glimpse into the world of public policy advocacy. I'm happy to answer any questions, and I thank you again for being here.
Hi. I always feel like I'm leaning down into a mic, so I'm just trying to get it so I can stand up straight. My name is Walter Long, and I'm a criminal defense attorney, and I've practiced habeas death penalty law here in Texas for a couple of decades. And it's a joy for me to be here today in some respects because I get to see some old friends that I haven't had a chance to see in a long time and share some hugs. I also started a project called the Texas After Violence Project back in 2007, which is a nonprofit oral history project receiving the stories from persons who are directly affected by murder and the death penalty in Texas. And I was motivated to start that by kind of analyzing my own experience in working on death penalty cases and the effect that those cases had on me, and seeing how those effects were kind of spread out throughout the system. Certainly the death penalty primarily engages me as a problem in relationship to the defense of my own clients. But it also even more fundamentally concerns me as a public health problem in relation to those who are charged with carrying out the punishment and those quite apart from the defendant who are directly affected by that process of which I am a part. So what I want to make very clear today is why I believe it's a public health problem and what the elements of that are. A death penalty case starts with a murder, and frequently everybody working on the case is subjected to a horrific crime scene. Aside from the surviving victims, police initially investigating a case perhaps are subjected to the most viscerally traumatizing experiences. I've worked on a case in which the police testified about walking into the crime scene and smelling blood long before they discovered the victims in the scene. Among themselves, police have to exercise massive restraint of their responses to what they see and experience. Once an arrest is made, the prosecution has decided to seek the death penalty, everything shifts in the direction of the punishment. The state's prospective act of violence becomes the overriding issue, and everyone, police, prosecutors, defense attorneys, judges, jurors, jailers, victims' family members and friends, defendants and family members, and ultimately wardens, prison guards, and governors, everyone becomes fixated on the punishment. In the present administration of capital punishment, lives are taken over by the drama surrounding the execution of the defendant, often for decades. We humans are biologically communal creatures, not isolated sets of individuals. We're totally dependent on the inner lives of others for our survival. If, for example, a human baby is fed and clothed but deprived of emotional contact, he or she will begin to fail and die. We share with other mammals a limbic region in our brains, which not only evolved to give us better means to process experiences that appear threatening to us, but also to provide us with what neurobiologists call limbic resonance, a means to immediately, unconsciously detect another's inner emotional state. We literally are dependent upon that contact in order to thrive. As well, that contact can become for us a source of what has been called emotional contagion. Verbal arguments frequently accelerate, for example, when we ingest on a nonverbal level another's agitated or emotionally dysregulated inner state, and we react. Limbic resonance and emotional contagion occur between individuals and on the levels of groups and entire communities, even nations. The ways in which we utilize our higher brains, our cortical processes, to make meaning of our experience contribute to our individual and communal emotional regulation. On individual and communal levels, constructive stories responding to perceived threats generally cool the system. Destructive stories, in contrast, perpetuate or enhance a sense of threat, spreading emotional contagion, at times triggering what's called traumatic reenactment, repetition of a triggering event. Neuropsychologists refer to individuals or communities in the thrall of destructive stories as trauma-organized systems. There are perhaps two principal elements in a trauma-organized system. First, a victimizer-victim relationship. The essential actors in the system include a victimizer who traumatizes a victim and the victim who's traumatized. In this context, there's an absence of a protector, or the potential protectors are neutralized. Second, the system is not self-aware and reenacts traumatic events. Within the system, individuals and communities create stories by which they live their lives, make relationships, initiate actions, and respond to actions. In the words of Arnon Bentham, a British psychiatrist, abusive traumatic events have an exceptionally powerful effect in creating self-perpetuating stories, which in turn create trauma-organized systems where abusive events are reenacted and reinforced. I believe that our modern experience with the death penalty is one such trauma-organized system. I believe it's a serious threat to our public health in three ways distinct from most other punishments. First, it's future-oriented. The death penalty is a story about a desired future punishment. Second, that punishment is overwhelmingly violent. And third, it emphasizes shaming. First, the death penalty is remote future-oriented. The state only secures at trial a conditional right to pursue execution of the defendant at a much later date. This requires the state to remain in an emotionally upregulated fight mode against the defendant for years until the execution takes place. I believe that for prosecutors, repeatedly pressing the death threat could be as emotionally dysregulating as it is for defense counsel, on the other hand, fighting against it. The future orientation leaves family members and other survivors of the murder victim in limbo, often unable to enter properly into steps of grieving, as they're stirred throughout appellate events to recall the sharp grief and trauma of their loss. As they may find themselves unable to process grief, their anger is also aroused at the defendant, at the defendant's advocates, at the prosecutors, and at the system. The future orientation also uniquely damages the defendant's families and friends, sometimes the defendant's advocates as well, who all undergo anticipatory grief, a constant threat of loss tied to actual repeated traumatizing threats, appellate losses, or state execution dates. The second way our death penalty differs from other punishments and is detrimental to health is that rather than erecting a bar to violence, it regulates violence. In most other contexts, law's function generally is to find peaceful means to transform potential physical disputes into words and to help parties find repose, aided by some non-lethal government action. In criminal law, other punishments as well are motivated by concerns about accountability, incapacitation, safety, and rehabilitation. However, in contrast, death penalty law, if we want to call it law, is designed to effectuate fair killing without excuse. Absent the exception that swallows the rule, pain and suffering arising only from lawful sanctions, the death penalty meets the United Nations definition for torture. The future orientation and extreme violence of the death penalty, in other words, the threat of homicide and the homicide itself, place it squarely in the category of events described by the Diagnostic and Statistical Manual as precipitating psychological trauma. In addition, in every death penalty case, as trial and appeal go along, repeated exposure to the facts of the crime occurs. For years, actors within the capital punishment system, including the advocates on both sides, and survivors of the victim and defendant's family, are trapped in a present moment between the past terrible murder and the state's killing in the future. The third way that I think the death penalty is uniquely unhealthy is that it's profoundly shaming in a way that no other punishment is. Justices Brennan and Marshall referred to the death penalty's fatal constitutional infirmity as the direct assault on human dignity, treating, quote, members of the human race as non-humans, as objects to be toyed with and discarded, unquote. In 1993, 3 Canadian Supreme Court justices described this even more colorfully. The death penalty is the supreme indignity to the individual, the ultimate corporal punishment, the final and complete lobotomy, and the absolute and irrevocable castration. It is the ultimate desecration of human dignity. This really vivid rhetoric in Kindler v. Canada helps very much, I think, to illustrate in every case the death penalty is an exercise of extraordinary shaming. If, in some abstract sense, it's also about incapacitating an offender, in real operation, it's about decapitating the offender. It's overkill. It's society's over-the-top response to what psychiatrist James Gilligan and others would call a narcissistic injury, in which society reacts in a trauma-organized way, perceiving its own cohesion to be under threat. Practically speaking, the shaming aspect of the death penalty dramatically heightens every conflict within its trauma-organized system, creating and sustaining multiple solitudes among all the stakeholders in relation to a death penalty case, and enmity rather than promoting cooperative efforts at justice. The surviving loved ones of a murder victim endure what has been identified as disenfranchised grief, which occurs when a loss cannot be openly acknowledged, publicly mourned, or socially supported. Now, this may seem surprising, but victim survivors often feel very isolated because people are uneasy in knowing how to be present and what to say to them. Beyond that, however, they can feel stigmatized by others for the loss of their loved one as though the homicide that occurred was somehow their failure. Their sense of being stigmatized may be enhanced by their having to take a position on the death penalty and feeling some backlash, feeling grossly misunderstood no matter what position they take. On the other side of the case, family members of the defendant also undergo disenfranchised grief, often feeling very shamed, as though they themselves are blamed for the defendant's behavior. The role of the trial and habeas attorneys to develop mitigation evidence enhances their shame, as it tends to validate their self-condemning feelings. Prosecutors in court also will say shame-inducing things about them in the process of trial. Moreover, family members perceive the theme of nobodiness being projected upon the defendant in the state's annihilating story as being about them as well. This is particularly dangerous as a matter of public health, especially when the defendant's family is already marginalized, as it actually is in most cases. Though through emotional contagion, this message of nobodiness not only can work its damage horizontally through the trauma-organized system, shaming family, friends, and advocates of the defendant, but also vertically, dangerously affecting the next generation, and in my view, setting the stage for traumatic repetition across time, victimization or perpetration or both in the next generations through the transgenerational transmission of trauma. So, I don't know, how much time do I have left? About a minute, my goodness. Wow. I would encourage everybody to go to our website, texasafterviolence.project. It's www.texasafterviolence.org. There are a host of resources up there. There are a lot of resources about particular stakeholders in death penalty cases. There are folks here at this conference who contributed heavily to that. For example, Michael Redolette, I think, was sitting over there but seems to have stepped out. So I encourage you all to look at those resources. And I was going to talk, and maybe I can talk maybe in comments afterwards about Napoleon Beasley's case and its role in my own experience of the death penalty, because I know it's going to come up with our next speaker and perhaps the one after that. I'm not sure. So thank you very much.
I don't It's a weekend. Yeah.
Thank you. How do I go forward?
Good morning. Hi, my name is Michelle Lyons, and for 11 years I served as the spokeswoman for the Texas Department of Criminal Justice. So in that role, basically I was the point person for the media for any questions that they had about the Texas prison system. And as you can imagine, most of those questions had to do with the death penalty. We would get hundreds of inquiries every year from media throughout Texas, nationwide, and definitely from abroad, especially European countries, about our use of the death penalty. So I thought before talking about witnessing, you know, a lot of people don't get the opportunity ever to go to the Walls unit and see where it actually takes place, or to the Polunsky unit where the men are housed for all the years before they're executed. So I brought just some photos so that you could kind of get an idea of what we're talking about and kind of be able to visualize it while we're speaking about it. The Walls unit, and it's called that obviously because of the giant red brick walls around it, the official name is the Huntsville unit, and it is the oldest prison unit in Texas. By law, all executions in Texas have to take place at the Walls unit, and it's been the responsibility of that particular facility to house the execution chamber since the state took over the role from the counties. You know, before then, the counties carried out executions themselves. Oh no.
You can.
Can I just do it on here?
Yeah.
Unless I'm pushing it wrong. Let me see.
No, it's not working.
Oh, it's not? Oh, okay. No, I love the clickers. It's like how I am with the remote. I really enjoy it. Am I doing it right? Okay, here we go. The men who are on death row do not live at this unit. They are transported to the Huntsville Walls unit on the day of the execution. So previous to that, they live at the Polunsky unit, which is about 45 to 50 miles east in Livingston, Texas. So on the day of the execution, the inmates are allowed to have about a 4-hour visit with their family and friends. Now, when they're on death row, they do not have physical contact with anyone other than the correctional officers who will handcuff them and take them to various parts of the prison. So when they have that visit, there's no last hug with their parents or their children or any of their friends. They have the visit. It's through glass using a phone, and I've got some photos of that. This is Polunsky. Now, it's a newer unit. It's obviously in comparison to the Walls unit, it's very stark. It's just kind of an ugly building, but it is extremely high security. This is all the razor wire that's around the area of the unit that actually houses death row, which is called Building 12. It's not only just all the razor wire, but there's also electric fencing. So in order to even escape from death row, you would somehow have to get out of the actual building, then you would have to get through the electric fencing, then you would have to get over this razor wire. So to date, knock on wood, there has not been an escape from Texas death row. This is what a typical pod on death row looks like. You can see, I see Anthony shaking his head. Spent too much time there. It's 2 levels, and as you can see, most everything there is mechanized. There's a control center that opens and closes the doors. They can turn on and switch off the lights, and everything is controlled from that. Now, the cell on the left is not actually a death row cell, but it gives you an idea of the close quarters. On Texas death row, you know, the men are housed alone in a cell. They don't have a cellmate. There's one person in one cell, and they're in that cell for 23 hours a day. The other hour, assuming that they're a level 1, which is basically, you know, good behavior, you get 1 hour of recreation. That's also solitary. So you go into a yard, which I have pictures of. As I said, when they have that visit before their execution, it takes place in this visitation area, and it is completely non-contact. So they're talking to their family and friends through this glass. You can see kind of the cage behind them. I mean, the officers put them in this little space, and then they leave. They unhandcuff them, and they leave, so they have their visits. After the visit's concluded about noon, that's when they're transported to Huntsville. And this is an aerial view of the Huntsville Walls unit. Let me see if I can better show you maybe this way. All right, obviously this is the front entrance that we showed. This over here is the actual death chamber. So when the van comes from Polunsky, it actually comes all the way back here. There's a very narrow little road, and you can see this gate. It backs up to the gate, and the inmate gets out, and he's brought into this area. This is the holding cell area. It's a big long hallway, and I'll show you there's several different little cells in here. And then this is where the chamber and the witnessing areas are, where the victims and the inmate's family get to collect and witness the execution. This is the entrance. So this is the door that the inmate actually walks into. And there's tons of locks and security to get into that area. And then beyond it is that holding cell area that I showed you. And again, there's lots of different cells because at one time this was Texas death row. There weren't very many men and they didn't wait very long for execution. So there was a very small area where they were housed. That open door, that is the chamber. This is it here. Basically, the men are strapped to the gurney by what's called a tie-down team. It's a 5-member team. These are usually big guys, and they escort the inmate into the chamber, and each one is assigned to a sector of the body. You have somebody who's responsible for strapping down the arms, the legs, the torso, and once the inmate is secured onto the gurney, we have an IV team that would come out. They're medically trained. They're not doctors. They can't be doctors because they cannot violate their oath. And they set the IV lines in place. If you look to the left, you'll see that window. That's that one-way glass so that the people behind the window can see in, but you can't see them. So no one ever sees the executioners. Their faces aren't ever seen. Their identities are not known. The IV lines come through that little hole on the left side. That's how they are able, from behind the glass, to actually physically administer the drugs. And I've had lots of people ask me about that. You know, I've seen on TV where they show this little machine, and the machine's really neat, and it pushes the drugs. It's not how it is. There is a person who does it by hand, so that person has no doubt of what they're doing. You know, it's not like the firing squad where only one person has a bullet. You know that you're administering the drugs, so it's a difficult job. Once the IV lines are established, that's when all of the witnesses are brought in. So it's my understanding since 1995, the victims were allowed to start witnessing executions. They're brought in first, and they are put in a room, this room, that is right next to the inmate's head. So when the inmate looks to the side, he can see all of the victim's witnesses. Once they are all in the room, then the inmate's witnesses are brought in, and they stand at the room to the right of this, next to basically the inmate's feet. And it actually makes it easier for the inmate to see his own family and friends. The two families never see each other, but they can hear each other. And to me, in some ways, it's a little bit disturbing because you have, you know, the victim's family, and they're here, and they have emotions, and the inmate's family is on the other side. And generally, by that point, there's not a ton of emotion being shown on the victim's side because they've gone through this process, they've had a lot of time, they've prepared. Sometimes you'll see crying, not often. But on the inmate's side, I mean, you have a mother who's witnessing her child be executed. And so you would hear a lot of emotion. There were times that, you know, you heard moms or sisters or family, you know, crying and wailing and stuff. And it never made sense to me necessarily that the rooms weren't more soundproof because in some ways, to me, it seems like that further victimizes both parties, you know, when you can really hear what the other side is going through, even though you can't see them. In addition, there are 5 media witnesses who can attend every execution, and that's really why I was even there. You know, initially I was a reporter, and so I witnessed in that capacity because the Huntsville item has a spot at every execution. After that, when I worked for the prison system, it was my job to take the reporters in and actually make sure that we always had someone on the victim side and someone on the inmate side. And I was very passionate about that because in my view, the media needed to be there because they needed to be able to record for the public what exactly was happening. And that includes whatever was happening in those rooms. You know, in one case, there was on the victim's side, there were 2 sons. This woman it was one of the few women executions. It was Betty Lou Beats. And the sons of the victim had high-fived. You know, the media needs to be there. On the flip side, you know, there was one execution where one of the inmates' mothers had to be brought out because she collapsed. You know, they need to be able to report that. The inmates are given an opportunity to make a really short last statement. Basically, the warden will tell them, okay, you have about 2 minutes. And most of them don't take that time. Most of them only take about 30 seconds. And it's funny, it seems like most all of them at the end will say, you know, warden, that's it, or warden, I'm done, and stuff. And they let the warden know that it's time to start the execution, which I always found somewhat unusual. You can see this microphone that's extending from the ceiling. there's speakers that are piped into both the witnessing rooms, and there's a speaker that's piped into the warden's office. And there's someone in the warden's office who actually transcribes all of the statements. So they can make sure, to the best of their ability, that they are put on the website accurately. Unfortunately, that doesn't always happen. And there were times as media witnesses that we would have arguments about what the person had said, because in one case, he started talking in a different language and nobody spoke it. And in another case, he was speaking very fast, or in another, he was speaking very low. So sometimes that was a little bit problematic, and we would have debates on what was said. Once the inmate had finished his statement, they would begin administering the chemicals. You know, all the executions that I saw were administered by the 3-drug mixture, and now they're done by 1. I've not seen one, so I can't really speak too much about that, only about the 3. And that process, when it was 3, it took about 2 minutes for the drugs to be administered, and then it was about 5 minutes later when a doctor would be brought in to pronounce the inmate deceased. And then this is the last slide. Following the execution, the inmate's body is taken to one of the local funeral homes. And at that point, the family can either claim the body and they can handle the burial, or, you know, unfortunately, funerals are very expensive. And in some cases, they just simply can't afford it. And so when that's the case, the state does handle the cost of the burial, and the families are welcome to attend, and they carry it out. And it's done just a couple of blocks from the actual facility. So, you know, I don't have a ton of time, so I'll just say, you know, my experience with the death penalty, I'm sure like anybody on this panel, you know, it was complicated, because I did not have really a dog in the fight. You know, my role was to be there and to witness all of them. And after a while, I found that it was just very taxing, because I didn't have a dog in the fight. You know, I didn't, it was hard to me, especially after I became a parent, to see the inmate's family go through that. You know, I'd always had a hard time watching the victim's family go through it, because I knew, you know, I thought, gosh, that's awful. I can't imagine, you know, all of a sudden your child's taken away or your brother's taken away. But I think after I became a parent, it became very difficult, because I thought, I don't understand the strength of some of these women who are able to go and watch their son die, you know, and yet felt so much that they needed to be there. And so, you know, like I said, it just became very complicated and stuff. And that being said, you know, I'm probably one of the few people in the room, I do support the death penalty. I think that there are a lot of flaws. I think, you know, the law of parties is extremely flawed. I think that people's access to, you know, DNA testing is extremely flawed. I think it's crazy that you have to have a court order to test DNA when, you know, it could very easily exonerate someone. I think, you know, in cases like Mr. Graves, where you're there just because one person said it, but there's no other evidence. I mean, there's a lot of flaws, but, you know, for the most part, you know, I support it. It's just, I just think it's such a complicated, you know, subject, and I think it's very beneficial that a conference like this is going on, because I think it's, my old boss used to say it's the ultimate, you know, carrying out the death penalty by the state is the ultimate bureaucratic act, and that's absolutely the case. So, thank you very much.
Wow, hello. It's a hard act to follow. Okay. And, you know, I'm glad I never seen that picture of the wall. You know, because even though I had 2 execution dates, I was never actually taken over there. That's scary, because I've seen a lot of guys that I grew up with basically behind those bars. They were over there. Some were mentally ill, some were innocent, most were guilty, but they all met their same fate. It was over there. Anyway, my name is Anthony Graves, and I am death row exoneree number 138. Back in 1992, a horrible crime had taken place in a small town, Somerville, Texas. And there was outrage. You know, a crime of this magnitude had never taken place in that small town. And so they wanted justice. As a matter of fact, the mayor came out the next day and said whoever had done the case didn't even deserve a trial. They should be caught and hanged, you know. And that's the way they pursued the case. Because a week later they had a funeral, and a young man showed up with bandages. He became immediately a person of interest to law enforcement. This young man happened to be the father of one of the victims in the crime, in the fire. So they followed him home, asked him if they could interview him, took him out to the DPS office where they interrogated him for over 14 hours. A lot of what he said today, then we still don't know today because they never really produced the tapes. And I'm sure that this young man was perhaps claiming his innocence, but more importantly, he was not lying on Anthony Grace for 14 hours until they asked him to just call a name, and they would let him go. Now, why did he call my name? Well, according to the young man, he said that when he was being taken to the DPS office, he seen a Jeep with 4 young black men in it, coming off the highway onto the field. And so he thought one of the young men was me. All right. And so because he thought one was me, when they asked him to call a name, he said he just called my name because he thought he had just seen me. But then he went and made up a story or 2 or 3 or 4 or 5 or 6 or 7, until it fitted their theory. And then they came and within hours arrested me and, came to my home. My neighbor told me laws were looking for me. And, I went looking for the police because I wanted to know, why were they looking for me? And, this is the moment where I always tell people, I don't care what you do. Don't ever go look for the police. Don't do that. Do not do that. Let them do their job. And the reason why I say that is because, when I went downstairs looking for the police, it took me 18 and a half years to come back home, 2 execution dates. I witnessed almost 300-some executions by the state of Texas, guys that I knew personally, from the ages of 18 to 70. They were all meeting their same fate. I remember I had been down there 12 years. When I tell you I witnessed guys attempting suicide, hanging themselves, slitting their wrists, cutting their throat, overdosing on their medication, and dropping their pills. Right? And you say, dropping their pills. It wasn't that because they didn't think they could win the case or continue to fight the case. It was the conditions. And I think Michelle can attest to the horrible conditions that those guys exist under. Not live, but exist under. Anyway, I went through that for 18 and a half years, 12 and a half on death row. And then in 2006, I was laying in my bunk listening to the Astros when we were good. We were really good. and this officer came by my cell, and she throws a note in it. Now, I know, Michelle, they don't supposed to do that, right?
No.
All right. But she throwed a note in it, right? A little humanity here. And so I look up and I say, what's this note for? And she said, well, some guy just told me to give this to you, another inmate. I think it's something about your case. And so when she told me it was something about my case, I paused. Because, see, down there, when you get a letter, you never know what's going to be in that letter. You don't know if they're saying that the state now has set you an execution date. You don't know if someone's saying that, family member, they heard a family member in your family just passed away, maybe your mother. It's never really a lot of good news on death row. But this time, when I got the note and I opened it, the note said, congratulations, man, I just heard on the radio that the Fifth Circuit just overturned your case. He said, man, I'll see you on the other side. Well, he's since been executed. He had an innocent claim, but he was executed. And so when I get that note, I'm excited. I want to pump my fist. I want to shout, But to my left, guy had a death penalty, a death sentence, was probably going to get executed. To my right, the same thing. I was surrounded by a bunch of men who was going to probably get executed by the state of Texas. And I just didn't feel that it was right for me to just pump my fist and shout because I just had some small part of victory. So what I did is I lay back in my bunk, and I just closed my eyes. I thanked my God. I pumped my fist, and I cried. Thank you, God, by time, And so that was in 2006. So the Fifth Circuit, most conservative court in our nation, The one where if God come down and testify, they're going to cross-examine and they're still going to rule against him. Right? That court right there gave me a 3-0 vote, unanimous, citing prosecutorial misconduct. Egregious. Not just prosecutorial misconduct, but egregious prosecutorial misconduct. And they overturned my conviction and told the state, you know, you had 180 days to retry him or let him go. Well, in my opinion, I just felt like the Supreme Court was trying to get the state of Texas to do the right thing. And they weren't trying to hear that, okay? Because when the local county came back and picked me up and took me to the county, you know, I'm thinking it's over with because the guy who had lied on me and put me in that situation was now executed. And on his gurney, he let the whole world know that he lied on Anthony Gregg. But not only that, but he had been telling the prosecutor from day one when they initially arrested him and then turned around and charged him that he had lied, that he had made all that up. Well, what they did is they hid all of that and they went and arrested and charged his wife with capital murder. And they put her in jail for like 2 months and then they let her out. Now, according to her story, she said Mr. Sylvester told her, you walk away from this case and don't look back. He didn't want her testifying. He didn't want her talking to the media. He actually wanted her to move out of the town and told her that if she said anything, that there was no statute of limitation on capital murder. Hint, hint, right? Okay. So now he put Mr. Carter in this position. According to Mr. Carter, he said, I have to keep now lying on Mr. Graves because if I don't, they're going to go after my wife again. And here it is. My son already doesn't have a father because he had been already convicted. But if I don't lie on Mr. Graves, he's not going to have a son, a father or a mother. But at least Mr. Graves' kids would have their mother. So I did the lesser of the two evils. I lied on Mr. Graves. That's his case. That was his story. And I ended up on death row, you know, for crime I knew absolutely nothing about. That happened in another town. I don't know the family. Family don't know me. I have no reason to just get up in the middle of the night and just go commit a crime, you know. But yet the system failed me, and I ended up on death row. And I watched. I'm telling you, I watched some of the worst inhumanity that one could ever think of. The way men are treated down there. It's horrible. It's really horrible. And it's in our name, the state of Texas. It's horrible. But anyway, you know, when my case is reversed and I go back to the county, well, we're excited. So we go back that Friday. That Monday we have a hearing, and my whole family and everybody's going to be there. And we're excited because they can't do nothing but let me go now. Surely the courts have spoken. Well, when I get back, I have a new judge on my case. And the new judge is now the daughter of the judge that sentenced me to death. And so we're asking her to provide us with information that she may have that will cause her to recuse herself from this case. Instead of her providing us with information, she brings in this judge that's her district judge and held a hearing on it. We didn't ask for a hearing. We wasn't even prepared for a hearing. The judge came in and denied us the hearing. And so she didn't have to turn over anything, and she stayed on the case, and she pushed the case 4 more years, 3 more months for prosecution. When they finally, when Kelly Siegler came on the case and finally dismissed the charges, they go to the judge to sign the order, and the judge was refusing. She didn't want to sign the order. She wanted this case to go to trial. And they had to tell the judge, look, we're going to go tell the media that you have an innocent man and you're refusing to let him go if you don't sign the dismissal order. So she said, fine. So she signed the dismissal order. And they wanted to bring me to the court and apologize to me in front of my family and friends and everything. And she said, I don't want that hoopla in my court. You can let him go now. When I don't look back, because I didn't care, right? Don't be like, oh, no, I didn't care. Right? As a matter of fact, when Kelly Siegler contacted my attorney, Nicole, she tell us, hey, Nicole, I can call the sheriff and tell them and have him release him now, Or you can go down there because you've been fighting with him for 8 years, and you can tell him yourself. And she had to drive like 2.5 hours to come to where I was, right? And so when she's telling me that, I got to thinking, hey, wait a minute. You could have just let me go and pick me up on the side of the highway, right? You know what I'm saying? Because what if they'd have changed their mind in these 2.5 years? Come on now, don't play. So, but I understood. But anyway, so when I get out, I've done a lot of work since I've been out. I've been out 5 years. I've created Anthony Gregg's Foundation, and all those is wonderful work. But one of the highlights for me is when I met the victim of the family that was murdered. It was the son. His name is Keith Davis. And I'm doing my own documentary. I was producing it, so they was like, well, have you ever tried to talk to Keith? Because I think Keith is the one that's kind of thinking that you was innocent. And I said, well, no, I haven't talked to them and wasn't really planning on it, because you have to understand, when games like that are played, you pit two families against each other. The whole time that we was going through this here, I hated them and they hated me. They hated me because they thought I murdered their family. I hated them because I thought that they had sided with a murderer trying to murder me. Okay? So we're not liking each other. But the whole time, we're not liking each other because we have a puppet master in our life, which is a DA, right? And so when we finally met and we talked, when we came in, he didn't know they were interviewing, I didn't know. And he was like, whoa, man, what's going on? So I said, man, let me talk to him, right? Because I got a lot of things I want to get off my chest to this young man. And so we sit there and we started talking about why we didn't like each other during this whole time, and come to realize that it wasn't that we didn't like each other. We just had a puppet master. We didn't even know each other. I didn't know their family. They didn't know me. But yet we were disliking each other. So the bottom line is we came together. And we came together after realizing that we had been played for 18.5 years by a prosecutor who wasn't doing anything but seeking victory. That's all he was doing. Right? And so from that, it brought two families now together. And we go out and kind of advocate at times together about the need for reform. Right? Big victory for victims and victors, because I'm a victim. Right? But more importantly, we were talking about victims. And I hear people always talking about victims, right? And their families. And I was saying to myself, I've heard everybody get up and talk about victims. And I never found a category that they talked about that put my mother in there, that put my children in there, that put my friends in there. So I'm saying we have to be careful who are we defining as victims. It's just not one side. Even if this man is guilty, when you kill him, you create another set of victims. It's just not on one side. So when we talk about victim reconciliation, talk about my family too. Okay? Talk about the men who's losing their lives, where their mother didn't have nothing to do with whatever they did. But she's now a victim. See, because society can be cruel to people like that. Because when they thought my mother had raised a murderer. So imagine how society was treating her for 18.5 years. She had become a victim. The state made my family a victim. So when we talk about victims and all that, understand that's on both sides. It's not just on this side. Because these people are innocent too. They didn't do anything that you're saying their son or their brother or their father did. And they love that man. So when you kill him, you create a whole other set of innocent victims. Okay? Let's start including them as well. When we put programs together, how can we make them get better? How can we make them feel? How can we make them move forward? Let's think about my mother and them too. Because my mother and them was put on death row for 18.5 years with me. 18.5 years. When I got my first execution date, my mother said this. My brother came to me, he said, Anthony, I'm so glad the state took the execution date back, because your mom said she didn't know how she could go on living if the state was going to kill her son for something she knew he did not do. That's a victim. Okay? So with all that I've done, like I said, I've started the Anthony Gregg's Foundation. I've started HIP, HIP, Humane Investigation Project. I'm out there doing the work trying to get people out that are innocent. I'm trying to help reform by talking about my story. But also, I got a clinic. And this clinic, and I'm going to leave it on this. I've started this clinic because what people are not realizing that when guys are coming out of prison, they have been at a high risk of infectious diseases such as tuberculosis, hepatitis, HIV, you name it. And they're going right back into the community. And there's nothing out here to help them make that transition. You got a healthcare community and a criminal justice community that is totally disconnected, and I'm trying to bring them together so they can save lives. With that, I know I got to stop, right? And the rest that I would love to tell you, you're going to be able to get it in my book one day soon. So, but thank you all for inviting me. I think this is very, very necessary and needed, because at the end of the day, you guys are talking about saving lives and reforming our system. And on behalf of those guys that I speak for, I just want to say thank you to all of you. Thank you.
I think if it's okay with Misty, we started a few minutes late, so I think we maybe have 5 minutes. We can take just a few questions.
Hi, thanks for being here. Oh, this is working. Thanks for being here. I have a question, I think, for Representative Cushing. So I'm a law student, and we have learned that a really big, of the many factors for why prosecutors seek death in murder cases, one of the really big factors is that the victims want it. And I wonder what you think the defense bar, the defense lawyer's role is in victim empowerment and victim outreach in the actual cases. So we've learned about defense-initiated victim outreach court sort of liaisons. I wonder if you think those people are a good idea, what you think beyond in the court of public opinion, in the defense bar sort of ceding or holding on to arguments. What do you think in actual cases, do you think the defense attorneys have a role in victim outreach and empowerment?
Well, I actually think there needs to be independent victim advocacy, that it shouldn't be. I think there can be liaisons, which I think is appropriate, between a victim and a defendant and between a prosecutor and a defendant. But the notion that there is the polarity of it is such that there's, you know, there needs to be independent victim advocacy. I think it's important that we try to sensitize the defense bar about the, you know, how the inevitability of re-traumatization, re-victimization that takes place for the victim survivor in our criminal justice process. I mean, trials are about winning and losing. They're not about, you know, truth-telling and healing and punishing. I mean, that's the reality of it. So, I think that I recognize that sometimes there's an inherent contradiction between that, and I know the perfect example is, you know, what do you do if you're a Devo, if you want to go if you're an advocate for an offender or a defendant, and you go to a victim and say, you know, is there anything we can do to help? And the answer is yeah. Ask them to plead, you know, to plead guilty, lay down the gurney, and take the needle and die, because that's what I want. That's kind of what I mean. That's an incomplete answer, but it's it's just looking at the kind of the set of parameters that you have now, and I think that we need to rethink a lot about our criminal justice system and the nature of the advocacy that we have.
Hi, I'm Jenny Sloan with the Constitution Project, and I just have a comment. One is that, ironically, we do a lot to try to close Guantanamo, and we're seeing the same situation replicated there. There are all these victims groups who are advocating for keeping Gitmo open and for the death penalty for the people at Gitmo, even the people who've been cleared for release. And so we helped start a group of family members who are opposed to the death penalty and who want Guantanamo closed, but it's the same thing all over again. It's really frustrating to see. But I also want to just particularly thank Rennie and Anthony for, Rennie, you started this whole victim or family members of murder victims movement, and I can't thank you enough. And Anthony, you're continuing it with the amazing work that you're doing, and I think that both of you and the work you're doing deserve all the support and all the resources that our community can garner. I can't think of anything more important. So I just want to say thank you.
Thanks, Jenny.
I don't want to take away any time from our last panel, so I think we'll stop there. Maybe people will be around a little bit later to chat more. Thank you guys so much.
Thank you.